Good evening. My name is Joanne Fine, and I am the chair of the Police Oversight Board. These are the other board members here, and welcome. We're glad you're here. There is a lot to talk about. One of these cases, case 093-17, is one that many of you have read about in the newspaper recently. This case involves a child abuse complaint that was reviewed by CYFD about Victoria Martens, who subsequently was murdered and dismembered, a 9-year-old girl. This case is a complaint by a civilian, Mr. Larson, who felt that the community had been, and the press had been lied to, and asked that we investigate whether or not that was the case. Mr. Harness, do you want to summarize what the findings are, or do you want me to do that? How do you want to handle this?
Chair Fine, we're prepared to have Investigator Scotch DePaul present the case.
Perfect. Okay, I have 2 questions, but I'll wait till after your presentation, Mr. Scotch DePaul.
Good evening. Chair Fine and honorable board members, my name is Paul Scotch DePaul. I'm a civilian investigator for the Police Oversight Agency. I was assigned this case after Mr. Larson filed his complaint. And to be honest with you, when I first started going into it, I wasn't sure exactly where I was headed. But the complaint was fairly specific from Mr. Larson as to what he wanted investigated. He wanted to find out where the information came from that was passed on from the public information officers to the media, who was responsible for that particular information. And he also wanted to make sure that the investigation covered whether or not SOPs were violated by department personnel. He wanted to know if there were any SOPs that maybe were gaps in the system, if there were procedural gaps. So it wasn't just a complaint about a couple of people who he suspected lied to the media. It was about really a review of the entire system. And that's sort of what the investigation took on as I went along with it and went into it. And I'll just tell you in summary sort of what I did with the investigation. I reviewed obviously the standard operating procedures, the complaint, the recorded interviews between the Albuquerque Journal reporter Elise Kaplan and Officer D and Director E. I recorded conversation with Ms. Kaplan, a review of the Albuquerque Journal articles that were printed in reference to this case, an interview with Mr. Larson, a review of APD standard operating procedures concerning juvenile investigations, a conversation with the former Crimes Against Children Unit Commander, Commander R, a conversation with the Crimes Against Children Unit Supervisor Sergeant E, recorded interviews with Officer D and Director E, a recorded phone message from reporter Elise Kaplan, and reviews of various emails, applicable New Mexico state law regarding assault and battery and attempted misdemeanors, applicable recognized federal law regarding consensual encounters between the police and citizens, and various other documents. So that was what the investigation encompassed as far as reference materials and what I did, who I talked to. Clearly this was a troubling case. We were able to identify 2 SOPs. The same SOP applied to both Officer D and Director E, and that is personnel will conduct themselves both on and off duty in a manner that reflects most favorably on the department, and that conduct on becoming an officer or employee of APD includes conduct that could bring disrepute, shame, dishonor, disgrace, or embarrassment to the department. With regards to Officer D, the investigation conducted by myself revealed that Officer D knowingly provided the Albuquerque Journal reporter with false information. The information revealed that sometime in November of 2016, the Children, Youth, and Families Department Cabinet Secretary and the Children, Youth, and Families Department Public Information Officer held a meeting at a CYFD facility. In attendance at that meeting were APD Chief E, Officer D, and an APD Crimes Against Children Unit Sergeant. At the meeting, CYFD announced that they were going to release a summary of their investigations related to Victoria Martens and her siblings. The 4-page summary of their investigations was provided to Officer D at that time. The summary showed that there had actually been 5 referrals to CYFD regarding Victoria Martens and her sibling prior to Victoria's death. All 5 referrals were cross-reported to APD's CACU, Crimes Against Children Unit. 4 of the 5 referrals were investigated by CYFD prior to being reported to CACU. Only 1 referral, and that's what I refer to as the attempted KISS referral, was not investigated by CYFD. APD did not investigate any of the 5 referrals sent to them by CYFD.
Wait a minute. Can you repeat that, please?
Yeah, APD did not investigate any of the 5 referrals sent to them by CYFD.
Okay, thank you.
The 4-page CYFD summary showed that on March 14th, 2015, someone called CYFD to report that Victoria Martens and her sibling had been exhibiting poor hygiene and were wearing dirty clothes, had been improperly disciplined by a grandparent, and the grandparent had consumed alcohol in front of the children. There were no allegations of physical abuse regarding Victoria and no allegations of sexual abuse regarding either child. CYFD investigators investigated and determined that the allegations were unsubstantiated. A year passed with no referrals to or from CYFD regarding Victoria Martens. On March 28, 2016, a source reported to CYFD that Victoria Martens' mother, Michelle Martens, had disclosed to the source that Michelle's ex-boyfriend had tried to kiss Victoria. Michelle Martens, according to the source, broke up with the boyfriend, and the ex-boyfriend no longer had access to Michelle Martens or the Martens family. The source noted that the information came from Michelle and that Victoria never made any disclosures to the source of physical or sexual abuse. CYFD noted in the following in their release. The information provided by the reporting party indicated that the former boyfriend was not a parent, guardian, or a custodian of Victoria. Therefore, it did not fall within CYFD's abuse and neglect jurisdiction as provided for in NMSA 1978, sections 32A, 42B, and F, note as it's noted. They also did not send the allegation to an investigator with the Protective Services Division because the matter fell outside of CYFD's legal authority to investigate it. So the attempted kiss fell outside the legal authority for CYFD to investigate. Because of that, they referred the matter to an appropriate local law enforcement agency, which in this case was the APD Crimes Against Children Unit. So in November of 2016, Officer D knew that the CYFD investigators did not go out on the attempted kiss referral. He was provided that information in the 4-page summary. It was there in black and white. In May and June of 2016, CYFD received 3 more calls about the Martens children. 2 of the 3 calls were made to CYFD by Michelle Martens herself. The 3rd was from another source. The allegations once again ranged from hygiene concerns to the children's biological father leaving the children with an unknown caretaker. CYFD investigators interviewed the children on all 3 of those referrals, and the children were asked about physical and sexual abuse, and the children made no disclosures to CYFD investigators about being physically or sexually abused. Those referrals were also sent to the CACU unit. The CPOA investigation revealed that later in November or possibly early December of 2016, another meeting was held in Chief E's office regarding the CYFD summary and the follow-up that APD's CACU did with regards to any of the referrals sent to them by CYFD. CACU Commander, former Commander R, and a CACU Sergeant E, Chief E and Officer D were present in that meeting. It should be noted that Director E was not present in either one of the reference meetings as she was on vacation at the time. Commander R informed the Chief of Police and Officer D that CACU had received the referral about the attempted kiss, but it was not assigned to a detective for follow-up because it didn't meet the criteria for case assignment. Information was also revealed in that meeting that after Victoria Martens was murdered, the FBI had come in to help with the follow-up on various aspects of the homicide. The FBI disclosed to the CACU that they had in fact been investigating the ex-boyfriend who had attempted to kiss Victoria Martens. The CPOA investigation revealed that the CACU receives hundreds of referrals a month, and they simply do not have the staff to assign every referral to an investigator for follow-up. Cases that are not reported to CACU, where a CYFD investigator has gone out and made a determination that allegations were unsubstantiated. Let me clarify that paragraph. So if CYFD gets a referral, they go out on it, they determine it to be unsubstantiated, they still have a requirement under the law to send it to CYFD, but CACU, but since investigators have already talked to the children, interviewed people, and the claims were found to be unsubstantiated by CYFD, an investigator would not go out, or the case most likely would not be assigned to an APD investigator at that point. Misdemeanor allegations of child abuse, and in fact, we actually have a misdemeanor child abuse on the books in New Mexico, are actually, there's no policy, there's nothing in APD's policies or procedures to have somebody go out and check those out.
At the misdemeanor level, you mean?
At the misdemeanor level, yes. Normally, if they can, if it does, maybe somebody looks at it and says, yeah, this is something that should go out, they can assign it to field services. There are a number of what are called care officers. They're trained in child abuse recognition, who normally those calls would be assigned to, or a field services officer to go out on and check that out. So getting back to Officer D, in late November.
Excuse me. Mr. Scotchapole, will you continue, please?
Yeah, Chair Fine and board members. So in late November or early December of 2016, the Chief of Police and Officer D were informed that no detectives from CACU ever went out on the attempted KISS referral. In January of 2017, Elise Kaplan, the Albuquerque Journal reporter, interviewed Officer D, and the recorded interview is full of false information provided by Officer D. And it's clear that Officer D was referring to APD detectives and not CYFD investigators. In fact, the documents and conversations with CACU personnel proved that Officer D not only did CYFD investigators not go out on the referral, but neither did APD detectives. Even though Officer D knew the referral was never investigated, he told Ms. Kaplan that it was. In fact, he told in great detail how it was investigated, and then he provided even more false information to Ms. Kaplan about just how and when a police officer can contact a citizen. Elise Kaplan asked Officer D if detectives went out and talked to Victoria about the attempted kissing, and Officer D replied yes. And this is a quote from Officer D. This is not from his interview with me. This is a quote from his interview with Elise Kaplan. He said, yes, the mom had told us that there was nothing going on in the home, and she removed the boyfriend. She told him not to return, so she was self-initiating at that point. And when the detectives spoke to the kids, they didn't make any allegations that anything happened. Officer D knew this information to be false when he provided it. Reporter Kaplan asked Officer D why the detectives didn't write a report. Officer D said that he didn't know why there was no report written, and he said, I'd have to talk to the detective if the detective still works for us and find out why. Certainly, he implied here that an APD detective followed up on the tip but didn't write a report. Officer D knew at that time that no APD detective went out on the attempted KISS referral. Elise Kaplan asked, but are you confident that somebody went out and spoke to Victoria and Michelle about it? Officer D answered, we look into a lot more stuff than CYFD actually gives us. We do a lot of secondary investigations on our own without having to give them to us to ask us to do the investigation, because there has been so many balls dropped on CYFD's end. A lot of the investigations that we investigate, we have to send off on our own because of stuff we've seen in their reports. And per state law, they're supposed to report anything they see as a criminal act to us so that we can investigate. If there's no criminal act that's founded, then we can't go any further. We don't have the right to go to people's houses and investigate them if they don't want us in the house. CYFD does. We have to actually have probable cause and a warrant in order to do that. If we don't have probable cause, we can't go further with our investigation. That is why we rely so heavily on CYFD, because they have the right to go into a family's home and investigate. Once they see a criminal act, that's when they report to us so we can investigate further. A lot of times we have to go off what they observe in order to have the probable cause in order to do a further investigations. If we don't get that from them, we don't have the right to be in people's homes unless they allow us in or unless we have a warrant. That is false and erroneous information. There are 3 recognized categories of Fourth Amendment police-citizen interactions. One is arrests, which require probable cause, which requires warrants at times. Detentions, which are justifiable by a lower standard of reasonable suspicion, and consensual encounters in which the police use no commands, force, lights, or sirens, but simply approach a person and engage them in conversation and make plain view observations without any official restraints, and for which no level of justification is needed because the encounter is not the seizure of a person. Most arrests based on probable cause, all investigative detentions based on reasonable suspicion, and all consensual encounters do not require a warrant. Officer D went on to tell Ms. Kaplan, when he was pressed for more information about what the detective did when he went out to investigate the referral, that he would talk to the detective, quote unquote, if he still works for us. But because there was no report, it would be difficult. Ms. Kaplan went on trying to find out, well, can you give me more information about this detective or these detectives? And Officer D again said, the information that was given to me.
Okay, Mr. Scotchapole, please.
Chair Fine and honorable board members, I was at the point where Ms. Kaplan, in her interview, kept trying to find out if APD detectives physically made contact with Victoria and Michelle in reference to the attempted kiss. And Officer D responded to her that the information was given to me that detectives went and talked to the family. That's where we got the information that the mother had taken care of the situation by telling the boyfriend to leave and not come back. Obviously, the mom was lying to us because she allowed the person back in, and she's allowed other people that were harming Victoria around Victoria. She asked Officer D would have made the attempted kiss a crime, and he said that the act would have had to have been completed. He told Ms. Kaplan that under state law, in order for an act to be considered a crime, the act has to be completed. That's also not entirely true. There are many attempted crimes on the book, including on the state law books, including attempt to commit a felony. In New Mexico, there is case law that there is no such thing as an attempted petty misdemeanor, however. Okay? As ludicrous as it seems, the lips are not considered to be an intimate part under state law. Kissing someone who doesn't want to be kissed is considered a petty misdemeanor battery under state law. It would be the unlawful intentional touching when done in a rude or insolent or angry manner. If one were to attempt an unwanted kiss and fail, it would likely be classified under the law as an assault, which is an attempt to commit a battery.
May I ask you a question before
Yes,
you go further? I want to know if there's a distinction between that same scenario being an attempted kiss adult to adult as opposed to adult to a child.
No.
There's no distinction.
There's no distinction under the law. So if one were to attempt an unwanted kiss and fail, it would likely be classified as an assault, which is an attempt to commit a battery. Assault is also a petty misdemeanor under the law. Assault is a crime under the law. A reported assault of a 9-year-old girl by an adult male warrants an investigation whether or not the perpetrator is still around. APD absolutely should have investigated this referral to assigned this referral to a CACU investigator or any other APD officer to investigate it. There was a reported crime committed, and it should have been investigated. Officer D said in his interview with Elise Kaplan that based on the information that both Mom and Victoria gave us at the time, there was no act that was completed that we could investigate. Mom said that this guy attempted to kiss her, but Victoria never said that. He said, there's no law that says you can't attempt to kiss somebody. Now, if he would have grabbed her by the arm or pulled her or done more, then that would be a battery, and that falls under a crime. More untrue information. Arguably, an assault occurred. When asked, what does attempted to kiss mean, Officer D responded, that's exactly what we were trying to find out. She asked him, what did you find out? And Officer D answered, both parties that we interviewed, the mom and Victoria, told us that we interviewed. Mom told us that he attempted, but didn't give us any description on how, and Victoria said that it never happened. So based on the information that detectives were getting, we couldn't go further lawfully, or we would have been violating their Fourth Amendment rights of illegal search and seizures, because that's exactly what we would be doing. If we force an investigation that we don't have enough proof to go forward with, we are now seizing them for an investigation which we don't have the lawful right to do. Again, this is more untrue information, as discussed above. There is nothing that prevents an officer from approaching a house where a child has allegedly been assaulted, knocking on the door and asking questions about the incident. There is nothing in the law that prevents an officer from speaking to the child and asking the child if something happened to them. And there's no seizure of anyone under the law. Ms. Kaplan asked, do you think that this is something that CYFD should have handled? And Officer D answered yes. And to that, once again confirming that he knew that CYFD investigators didn't go out on the referral either. Officer D then went on to heavily criticize CYFD and said that APD has to often force CYFD to conduct investigations. Towards the end of the interview, Ms. Kaplan asked for some proof of a recording or something that would show the detectives went to the house, and Officer D said that that's where they needed to be careful, because if the police track information on people that don't have criminal history or don't have a criminal investigative need, then the police would be surveillancing people, and it's against the law for the police to do that. She said she was just asking for a record of the call, and she told Officer D that she was skeptical of what he was saying because there was no record of a response to the referral. Officer D said, I would have to talk to my detectives because, like I said, I got this from my detectives from conversations that we've had numerous times about this. He then went on to say that the police can't just go out and investigate someone because there's an allegation made against them. Again, that is untrue. If that was the case, no tip on people breaking the law could ever be followed up on by the police. He said that if a person is investigated and the information turns out to be wrong, then the police could be sued for conducting that investigation. And he said there are too many things now that restrict the police from doing their jobs. It goes on. She asked for more proof, and then he says that I don't know if the report's being held up because the murder side of the case still hasn't been closed. I don't know. Maybe that's why we don't have a report available yet. And then Ms. Kaplan said, well, I'm going to write, that we have to write in the report that you said, that Officer D said that the police responded, but there was no proof that APD did. And Officer D then told Ms. Kaplan to file an IPA request for the report on the contact, because if the file was a protected file, it wouldn't be available and it wouldn't be in the public record. She asked for a case number or something that would help her get it. And Officer D responded, well, if I can't get it, they won't give it to me, they won't give it to you. It has to go through city legal and I can't make that decision. Ms. Kaplan asked Officer D if he was willing to talk to his detectives, and he said that he would, but if the case was still being worked, there was nothing he could do, and that there are lieutenants and sergeants above him that would tell him to beat sand. And then in a follow-up interview the following day, Officer D told Ms. Kaplan that he couldn't release the names of the detectives who went out and followed up on the referral. Keep in mind that he knew in November and December that there was no investigation by either agency. And then he says that he couldn't release the names of the detectives who went out and followed up on the referral because they work a lot of high-profile cases, some of them with the FBI, so if their names are released, that could compromise other children's cases, and we have to make sure that we're not going to re-victimize those victims whose cases have been investigated. He continued his deceit with Ms. Kaplan, inferring that he knew the names of the detectives who went out on the referral, but he had to be careful about releasing their names because he didn't want to jeopardize any cases. The investigation revealed that there are no CACU detectives assigned to the FBI. CACU detectives' names are public record. The names of the APD CACU detectives being released can't jeopardize any child abuse or neglect information. They sign the complaints against the very perpetrators whom they incarcerate or charge with crimes. Again, documents and other APD personnel interviewed proved that Officer D knew when he gave the first interview that no one from APD ever went out on the attempted KISS referral. He surely knew at the second interview that no APD detectives ever went out, yet he made up the details that simply were not true and embellished the information so that one would think that if he did release the investigating detective's name, somehow other children would be victimized. All of the information that I've just relayed to you proved by a preponderance of the evidence to me that Officer D intentionally lied to Ms. Kaplan during his interviews with her in January of 2017. And not only did he lie to her about what APD detectives did to follow up on the referral, he also provided her with false information about citizen-police interaction. These lies about APD following up on the referral were printed, making the citizens believe that APD had in fact followed up on the referral and everything had been done by both agencies properly, and nothing could be further from the truth. As Mr. Larson complained, the public must be able to trust the police department to provide truthful and accurate information regarding the actions taken or not taken by their officers. That trust was violated when the department provided false statements to the public regarding actions or inactions of detectives regarding the CYFD referral. I recommended a finding to the full board that the conduct be sustained where the investigation determined by a preponderance of the evidence that the alleged misconduct did occur. With regards to, would you like me to continue?
Yes.
Okay. With regards to Director E's conduct, again, it was the same SOP that we looked at, and that was conduct that could bring disrepute, shame, honor, disgrace, or embarrassment to the department. And the investigation determined that Director E gave the reporter the same wrong and misleading information that Officer D did. The investigation showed that Director E was briefed on the homicide 2 to 3 days after it occurred, and during that briefing was made aware that CYFD referrals had been made to APD, but at that time, just 2 days after the homicide, they didn't know what the status of those referrals were, who went out, who CACU detectives at that briefing said that they would be following up and they would be letting them know what the department's response was to those referrals. The investigation showed that Director E was not present for the meeting that took place at CYFD where the 4-page summary was released of the referrals was released to Officer D. And Director E was also not present when a second meeting took place in the Chief's office to discuss what APD's response to the referrals was that was sent to them. The CPAOA investigation revealed that Officer D was the lead contact for the media on this case, and he was the one who preliminarily provided most, if not all, of the incorrect information to Ms. Kaplan. In January of 2017, when Director E was getting ready to speak with Elise Kaplan over the phone about APD's response to the referrals, she met with Officer D and discussed what APD's response was. Officer D gave her the exact false and erroneous information that he had provided to Ms. Kaplan. Because of their working relationship, Director E trusted Officer D trusted what Officer D told her, and she did not feel the need to re-verify the information before speaking with Ms. Kaplan. Director E said in her interview that the information that Officer D provided to her led her to believe that APD detectives had in fact responded to the referral of the attempted kiss. She believed that the detectives questioned the mother and the girl, and there was nothing further that the APD detectives could have done. She was led to believe that APD detectives had followed policy and procedure and that APD did everything they could have done in response to the referral. She was also briefed by Officer D on why APD couldn't do more with the referral and was led to believe that if APD had pursued the matter further, they would have been violating the family's rights. All of the information that she provided to Elise Kaplan in the first phone call was provided to her by Officer D. Director E does not have a background in law enforcement. She's never been a police officer. She's never attended a police academy. She was a TV reporter, and then she took a job as a PIO with the Santa Fe Police Department. She later took the director position with APD. She has never been formally trained in the difference between probable cause and reasonable suspicion, nor has she been formally trained on the types of police and citizen encounters. In her job, she relies heavily on what police officers and detectives tell her, and she relies on those officers to tell her what she can and cannot release. She expects the information that is being provided by the officers to be truthful and factual. Director E was contacted by CACU Sergeant E when the Albuquerque Journal broke in January of 2017. And she was told that CACU detectives did not go out on the referral. This was in January 27th or 28th of 2017. Not only was Sergeant E, who was the CACU sergeant, shocked to read in the newspaper that they had, but Sergeant E had in fact informed Officer D prior to the printing of the article that APD CACU detectives never went out on the referral. Director E maintained that she questioned Officer D after she spoke with Sergeant E. So once she finds out, she maintained that she went to speak with Officer D, and it was only then that Officer D told her that when he gave Ms. Kaplan the information that he was referring to CYFD investigators and not APD detectives. Director E said that she informed the chief of police with the miscommunication, which she classified as a miscommunication, with Ms. Kaplan, and she said that she contacted Ms. Kaplan to inform her that the information that she had been provided was wrong and that APD never went out on the referral because it did not meet APD's criteria for case assignment. Director E said that she emailed Elise Kaplan and they emailed back and forth. It should be noted that Director E said she contacted Ms. Kaplan by email and she and Ms. Kaplan emailed back and forth. The CPOA investigator, I contacted Director E's attorney and requested copies of the email exchanges from his client. The investigator also contacted Ms. Kaplan and asked if an email exchange occurred between her and Director E regarding the erroneous information that was provided to her by Officer D. Mr. D'Amato, who is the attorney for Director E, told the CPOA investigator that Director E was going to look for the emails and she would contact the CPOA investigator directly when she had them in her possession. Reporter Elise Kaplan said that Director E did not reach out to her to correct the record as Director E had purported in her interview with me. Ms. Kaplan said that she was the one who reached out to Director E in March, on March 3rd of 2017, and that's when the email exchange started. And the email exchange actually is more about, I need to speak with you about this. Can you please give me 20 minutes of your time? I need to talk to you. It was not until March 13th, 2017, in that recorded interview that Director E told Elise Kaplan that APD did not go out on the attempted kiss referral. So she knew in January 27th or 28th of 2017, that they had provided false and erroneous information or miscommunicated information to the journal, and it takes till March 15th to correct the record. I did obtain the emails, and the emails also contain incorrect information. Talks about seizures, talks about we would violate somebody's rights, things like that. So,
We're running long on time. Can you
I'm sorry,
get to
I'm
the...
going to wrap it up
Okay,
very
findings.
shortly. So one of the things, that was mostly what I found that was not a positive reflection on the department. She had known for at least a month and 10 days that the information was false and erroneous, and she didn't reach out to the media to correct it. And she, knowing that she provided false information to the media, when waiting a month and a half to correct it, even under submersible pressure and copious criticism, flies in the face of transparency and integrity, and the conduct reflects badly on her division, and the APD as a whole. So I recommended also that that finding be sustained. There were also further conclusions and recommendations that I made, that we made. I want to make it clear here tonight that there was no evidence that was uncovered during the investigation that suggested that there was any type of collusion or conspiracy among other members of the department, that the false information that was released to Ms. Kaplan was generated by anyone other than Officer D. It's troubling that in reviewing policies and procedures that APD has no written policy or procedure in place that addresses exactly how CYFD referrals are handled. There's a process, and I could go into it more for you if you have a question for me about it, but I would like to see the Policy and Procedures Subcommittee of the Police Oversight Board work on this issue by working with APD to formulate a standalone policy that specifically addresses how APD will respond to CYFD referrals in the future. And with that, I think I pretty much briefed the case and what the investigation was, and I stand for any questions.
I have a question. You said that 2 of the meetings that happened took place in the chief's office. Is there a reason, did you interview the chief? And if you did, what did you learn? And if you did not, why did you not?
Chair Fine, board members, I did not interview the chief of police. The investigation originally was directed at Officer D and Director E, and it was about their lying to the media. The investigation, the citizen requested that we look at policies, procedures, what policies were followed, if somebody violated some policies or procedures. This was obviously a long investigation, and I didn't have any reason with the information that I was provided, with the evidence that I had, to go forward in questioning the chief. I have Officer D confirmed the meetings, the CACU sergeant confirmed the meetings, the CACU commander confirmed the meetings. So I knew that the meetings had taken place, and I knew what the content, or at least what some of the content of the meetings was. I didn't have any reason at that time to ask the chief about what happened in those meetings, because I had a whole bunch of other people that had provided evidence as to what had happened in the meetings.
But if you look at the whole timeline, these meetings happened in December and January, is that correct?
November
Oh.
November was the CACU meeting. December of 2016 was...
And those are the meetings the chief was at?
Yes.
And so in the interim, subsequent to those meetings, lies come out in the paper that certainly everybody in that meeting should have believed. They heard what was said at the meeting, that being that they didn't go out.
Yes.
So the chief was in those meetings, correct?
Yes, that's correct.
Okay, but yet you say you're confident there's no collusion on there, that the Officer D did this all by himself. So how do you know that if the chief was there and it comes out in the paper and then he doesn't do anything to correct it either? So nobody did anything to correct this error. Even if there was no collusion, one would think that there would be some correction on the part of the chief. Did that thought cross your mind?
I don't think that actually crossed my mind at that time. I was led to believe, in conducting the interview, I was led to believe that this was something that was taken care of almost immediately. I wasn't told that it was taken care of immediately.
You mean not 6 weeks later?
Exactly.
Okay.
I was led to believe that it had occurred very quickly. As soon as the information was released that there was somebody had gone to the chief and said, hey, we did this, I didn't ask what was the chief's reaction. I asked questions because one of the things that Mr. Larson was concerned about was this some sort of conspiracy, some sort of a concocted story that was put together to protect the image of the Albuquerque Police Department. And I asked questions in my interviews that were specifically related to that. And I have to go on what I'm told. And what I was told is that there was no collusion, that nobody came up with a story. The evidence points to Officer D coming up with the story. Sorry.
Okay.
Almost made it.
I want to ask another question that has to do with the recommendations for discipline, which is an attachment to this letter to Mr. Larson. It is our suggestion, as I recall, that Officer D receive a letter of reprimand and an 80-hour suspension, and that Director E receive a letter of reprimand. Now, we all know that that is based on the Chart of Sanctions piece. But a question was asked of me, which I thought was a good question, even though I think I know the answer, I want to ask it anyway. Did the staff consider, Mr. Harness, did you consider recommending termination? If so, what led you to not do that, and if not, why not?
Chair Fine, the level of sanction for this particular SOP does not allow for the evaluation of termination. It does not go to a level 1. It simply goes to a level 6. So therefore, the only remedy available under the Chart of Sanctions was in accordance with the Chart of Sanctions level 6. And based upon the disciplinary history of Officer D, his disciplinary history made it rise to a level 4. So therefore, that's the recommendation for the 80-hour suspension. And when we were making this recommendation, we became aware simultaneously that he had been removed from the PIO position, but we were recommending his removal from the PIO position. And as far as the Chart of Sanction for Director E, a level 6 first violation is a written reprimand. The Chart of Sanctions delineates these are the appropriate sanctions.
And tell everyone here, because I'm not sure every board member understands this as clearly, what ties us, the CPOA, POB, to the Chart of Sanctions as a recommendation relative to discipline?
Well, APD policy, I believe the number now is 3-46, lays out the amount of discipline and the level of sanctions appropriate for SOP violations, and that's what we are bound by in accordance with APD policy.
In addition, aren't we bound by that, by the ordinance? The ordinance says that that's what our discipline recommendation should be based on, is the Chart of Sanctions. It says that in the ordinance.
And the ordinance as well.
Okay, I just want to be clear about that. We are tied, because of the ordinance, to making recommendations that are within the Chart of Sanctions. That's what the Chart of Sanctions says. That's what limits our capability in terms of what we can recommend for discipline. That is why we can't recommend termination, because the Chart of Sanctions doesn't allow it, and we're tied to that. Does anybody have any questions about that? Anybody have any other questions?
I have a comment. First of all, I want to thank Mr. Larson for bringing this to our attention. If it hadn't been for his complaint, we probably wouldn't have never known about it. And I think Investigator Scottsapole did a great job on this. I mean, I'm sure it took a lot of your man hours and a lot of time to pull this together. And I think you did a very thorough job with that, and I appreciate that. Thanks.
Thank you.
I agree.
So just to be clear, we are not investigating at this point. This investigation was not about what APD chose to do or didn't do relative to Victoria Martens. It is about lying to the public. That is the complaint that we're dealing with. The recommendations, however, as was envisioned in the ordinance, there may be cases where we see things that we make recommendations on policy. So the policy things have to do with that. And so we are seeing both of those in this case. And I just want to make sure that that's clear to people. This is not about judging the behavior of APD on this particular case. Should they have gone out? Shouldn't they have gone out? They have lots of things to deal with, and it may have suited their SOP. This was about lying to the press and lying to the public. And they did do that. We were able to confirm that, and we make discipline recommendations. Subsequent to that, we are also making recommendations to the police department relative to policies that are lacking in this area. So that's the policy part, and that's what Dr. Cass's committee will deal with. Thank you, Paul.
Thank you.
Okay, cert cases. We don't have any. We need a motion.
I believe we need to vote.
Oh, yes. Okay, so we have a motion and a second to
Second
accept
motion.
the cases investigated as written.
I'll second.
I'll move it.
All those in favor?
Aye.
Aye.